It's my pleasure to introduce our next speaker for this session, Alex Cutler. Alex is a partner at Eittreim and specializes in the areas of divorce and family law, including divorce litigation, child custody litigation, alimony and child support matters, modification of custody and support, and contempt actions. Before joining Eittreim as a partner, he was previously a partner with the family law firm of Lawler, Green & Pritz. Prior to that, he spent 7 years as a litigator with a mid-sized Atlanta firm where, in addition to practicing family law, he specialized in the areas of commercial litigation, real estate litigation, and lender and debtor workouts and litigation. As a result of his diverse professional background, Alex is well suited to assist clients whose cases may involve complex business interests and extensive property holdings. In addition to many other accolades, Alex has been named a Georgia Rising Star in the area of family law by Super Lawyers 2014 to 2019. Alex has been a member of the Georgia Bar since 2004 and is currently a member of the State Bar of Georgia, the Georgia Court of Appeals, the Georgia Supreme Court, and the United States District Court for the Northern District of Georgia. Alex is very active in the Atlanta Bar Association, where he sits on the board of the Family Law section. With that, I'll turn it over to Alex Cutler.
Thank you very much. I was going to ask if you can hear me, but I'm getting the reverb myself, so I think we're good. Thank you for coming to the fun breakout session where we get to talk about the fun aspects of divorce and family law. It's a pleasure to be here today, and I want to thank you all for inviting me to come speak. It's always a pleasure when I get to talk to people who are not lawyers about what it is that I do. My topic today is the economics of divorce, and I kind of was thinking about it quite a bit when I was first approached about talking about this, and you might as well call it what I do for a living. It's a rather broad topic because everything I do, other than child custody matters, really relates to money matters. So what we're going to be talking about today is the role of financial advisors and analysts in divorce matters, equitable division of property, which is how we address property holdings in marital estates and divorce actions, the concepts of marital versus separate property, the concept of support, primarily alimony, and there's some very interesting new developments in the world of alimony thanks to recent tax law changes, prenuptial agreements, or how you protect what you've got, and we'll kind of sprinkle in some tax considerations that kind of permeate all aspects of divorce law. What we're not really going to focus on today, because I don't really think it's germane to what y'all do and what I'm here to talk about, is child custody. Obviously, a big part of any divorce action is if they're minor children. It's actually the primary part of any divorce action is the child custody piece. We always try to put the kids first, but we're not going to address that today. I wasn't going to spend much time on child support. There may be, because some interesting income issues have arisen, there may be an occasion to sprinkle in some information on child support. And if anyone in this room, as we're wrapping up, has any questions about child support, I'd be happy to address those with you. The three things that divorce are about other than child custody are money, how much I will receive and how much will I have to pay. Again, money, how long I will be able to rely on what I receive, and how long do I need to work to pay what I am required to pay, and just for good measure, money. That's what divorce is all about. It is a settling of an estate between two people who happen to just have a very intimate relationship with one another. I like to say that divorce is an emotionally charged business transaction. The decisions that we make in a divorce case are often no different than you would have to make in a typical business dissolution of partnership action or anything along those lines. The problem is we're dealing with emotions that go way beyond what you would normally deal with in an arm's length business transaction. A lot of times what we're dealing with is fear, anger, betrayal, relief, jealousy, you name it, we have to deal with it. And what that does is it creates a fog. And that fog creates issues with us trying to advise our clients as to what makes the most sense for them economically. Because at the end of the day, that's what we're there to do. A lot of times I'm asked the question by clients, I want to win this divorce case. And I say, okay, well, I want a lot of things. That doesn't mean it's going to happen. You don't really win a divorce case. If someone asks me what is a winning outcome in a divorce case, I'm going to say this. If my client comes out of this divorce case in an economically stable position where they're not concerned about their finances or where they're not concerned about how they're going to feed themselves, house themselves, retire one day, I've done my job. I want to put my clients in a position where they're economically comfortable. And if I've done that, then they're good. Sometimes, unfortunately, that's not always possible. One thing I've noticed is some of the most difficult cases to settle, if we're going to settle a divorce case, are the cases where there's too much money, because there's too much to fight over and the numbers are just astronomical and people can't wrap their heads around it, or when there's too little money, because that limits our options and it limits our ability to actually solve the problems we need to solve. And sometimes in those situations, we're talking with people about making some very hard decisions. The way I thought about approaching this talk today is selfishly the way I like to look at problems, and that's doing a fact pattern. I've tried to create a fact pattern that, while there might be some logistical issues when you try to meld things together, kind of covers a lot of the issues that we'll typically see in a high asset divorce case, and that's primarily what my firm does and what I did at my prior firm as well. So I thought the best way to kind of work it up is create a couple for us to talk about, go through some of the issues that we'll typically see in a divorce action like this, and then be happy to answer any questions you might have. So let's start with our fact pattern. John and Sally were married 30 years ago. There is no prenuptial agreement. John is 61 years old and Sally is 57. At the time of the party's marriage, John was an associate at a large law firm making $70,000 per year. I have no idea if $70,000 per year 30 years ago was accurate. I know when I came out about 16 years ago, it was about 100, so I'm just kind of trying to adjust the money accordingly. After 5 years of marriage, John was named a non-equity partner, making $200,000 per year. After 12 years of marriage, he was made a full equity partner. For the last 18 years of marriage, John's income has averaged in excess of $800,000 per year. John expects that he has another 5 to 7 years at which he can expect to earn at this level before firm policy will move him into a reduced, less lucrative role as he reaches retirement age. For those of you who work with lawyers who are equity holders in large law firms or along those lines, you will often see that there's a desire to kind of move new blood in, move older blood out. So a lot of times when you hit retirement age, you're going to see people lose their points, lose other things that kind of, I call it putting them out on a nice flow, but put them out a little bit so they don't have the economic wherewithal of prior years. At the time of the marriage, Sally was also an associate attorney, though at a smaller firm. Sally was making $50,000 per year and had been out of law school 4 years less than John. John and Sally had a child after 3 years of marriage. Sally decided to go back to work after the baby was born. 2 years later, like everybody I know, including myself, well, not myself, I didn't give birth to twins, but Sally gave birth to twins, I had twins, one of whom had some special needs. As the birth of the twins coincided with John's promotion to a non-equity partner role and the associated increase in income, which more than doubled his income, John and Sally decided that Sally would leave the practice of law and focus her efforts on raising the children, including taking the lead on caring for their special needs child. When John became a non-equity partner, he began working with Karen, a financial advisor and analyst at a large investment firm. Karen and John, working together over the last 25 years, have managed to grow John and Sally's net worth to a total of about $12 million, a little over. John and Sally's net worth is generally broken down as follows. He used about $3 million in retirement, $500,000 in a money market, $150,000 in cash, $4 million in investment accounts, $1 million in John's capital account with his firm, $2 million in equity in the marital home in Atlanta, $1.2 million in equity in a vacation home in Rosemary Beach, which appears to be the popular destination in a lot of my cases, $500,000 in various business interests in which the parties are invested, and that's being generous, because usually when I see that lawyers or doctors are invested in businesses outside of their given field, they're not generally doing all that well. The kids are now grown and are living on their own. About 8 months ago, as so often happens, John had a month-long relationship with another woman, and Sally has decided to file for divorce. So when Sally or John comes into my office, I'm going to take Sally for the purposes of this example. When Sally comes into my office, the first thing we're going to do is do somewhat of an economic assessment. I'm going to hear out everything that happened. I'm going to hear about all the things that gave rise to the dissolution of this marriage, how they met, how they came together, how they allocated responsibility for finances, how they allocated responsibility for child rearing, how they found themselves in the position that they are now in. But at the end of the day, what I'm really wanting to do is not only assess my client as an individual, but I'm going to want to do an economic assessment of my client. So the first thing we're going to do is I'm going to try to determine what are the assets and liabilities that are going to be equitably divided. Are there any assets that we are not going to be able to divide? Are there any assets that Sally may want to stay away from? Okay. It is not uncommon. Sally is what I would call a non-moneyed spouse. It is not meant to be derogatory. It just means that a lot of us divorce lawyers use this term. non-moneyed spouse. The moneyed spouse is the person who's typically earning the income, the person who's managing the income, the person who's got the money coming in. The non-moneyed spouse is the party who has either been responsible for homemaking or has been otherwise employed in a role that is not a primary income generator for the marriage. So if Sally in this situation is the non-moneyed spouse, I'm not going to be surprised if Sally's not going to know a whole lot about what the parties have. The person who probably is going to know the most about that is going to be Karen, the financial advisor, who's been managing their money for the last 25 years. Next thing I'm going to try to look at is what is Sally's ability to contribute to her own economic needs, and in that sense, is this an alimony case? The nice thing about this fact pattern, if Sally's coming to see me, is that Sally has got, and John, have managed to accumulate some net worth. They're not terribly young, but they've managed to generate somewhere over $12 million worth of assets between the two of them. So there is something for us to work with as divorce lawyers and try to solve these problems for these families. What we try to determine is, if an alimony case exists, do we need to put Sally in a position where just the assets she's going to receive in the divorce case are not going to be sufficient for the purposes of providing for her needs for hopefully the rest of her entire life? So we're going to assess that piece of it. Who do we need to bring in to help value any non-liquid assets? Now in this example, I tried to throw in some business assets because more and more what I'm seeing is, in our cases, closely held business interests, minority interests in various, you name it, companies, manufacturing companies, family businesses. More and more that's becoming something that has developed in my practice, much more than your typical W-2 employees, your K-1 employees are becoming more prevalent. And I think what we need to determine is, how do we value those minority business interests, okay, if we have it? How much is Sally going to need to receive to meet her economic needs? This is one of the harder parts that we have, because presumably Sally and John have developed some level of a style of living. If they're living in a $2 million house in Atlanta with a $1.2 million house in Rosemary Beach, chances are that they've been living a fairly comfortable lifestyle, given the money they have in the bank, the money they have in retirement. So what is Sally going to need to do? Is Sally going to need to have a change in lifestyle? Is there enough money to allow Sally to continue with her standard of living in perpetuity? How much are we going to need to do that? And what we will typically do in a case like that is prepare something called a domestic relations financial affidavit. Some of you may have assisted in preparing these for your clients over the years, especially some of you who have clients that have very diversified asset holdings. But a domestic relations financial affidavit is something that it's kind of the Bible of a divorce case. It's something that basically sums up a party's economic position in one document. It breaks down into your income, your budget, everything that you have on a monthly basis, all of your assets, and all of your business holdings. It gets synthesized into one document that we can refer to throughout to determine how much Sally or possibly John is going to be able to either pay or need to receive to meet their needs. So that's going to be another thing we're going to do. And who can help us ensure that Sally's not going to run out of money, and is that even possible? The goal for my case, anytime I have someone who is past what I would consider to be middle age or who is approaching retirement age, if I can, I want to get them through the rest of their life without running out of money. I mean, that's primarily what I'm going to be looking for someone to help me to find a way to do. And when I'm talking with economic advisors, financial advisors, investment people, I'm going to want to talk to someone who can sit down with Sally, because she's going to need someone, right? Karen has been their family's financial advisor for the last 25 years, but Karen's relationship is with John. So Sally's going to need someone who can come in and help manage whatever assets she's going to receive in this divorce action and help her grow those assets so she's not going to run out of money. Because I guarantee you, if Sally's like most people, men or women, if she's not the one who's earning the money, she's scared, okay? And if she's scared, she's going to need someone who can help her realistically grow the money, not overpromise, and that's someone I'm going to be looking to. So one of the things that we're going to do once we've got Sally in and we've talked with her about kind of what we have, and if we can try to figure it out, is we're going to talk about equitable division of property. Now Georgia uses one of the two methods, obviously, there's only two, of dividing property. One is equitable division of property. That's what we do here in Georgia in about half the states in the country. And the other is community property. If you ever watch tabloid shows, your TMZs, they talk about divorces in California, you'll hear about community property. Community property generally, and I don't have to deal with it very much, thankfully, because I'm not licensed to practice law in any state that has it, is if anything's marital, it gets divided 50-50. In Georgia, we have what I consider to be a much more preferable economic or asset division structure, and that's equitable division. Equitable division of property does not mean an equal division. It means a fair division of property. All right? So if there is $12 million in assets, it's not that each gets 6. John may propose that in his divorce settlement offer. He might say, you get 6, I get 6, let's call the whole thing off and go our separate ways. It means what's fair. So if Sally's in a position where it makes more sense from a fairness standpoint to give her more than 50% of the assets, the court has the power to award her more than 50% of the assets if we go to trial. Okay, so that's a big factor that we look to in trying to decide what makes economic sense for our clients. Only marital property is going to be subject to equitable division by the court. Okay, and marital property is defined as follows under the Payson case. I just grabbed it out of Payson, but it's defined several other places. Only property acquired as a direct result of the labor and investments of the parties during the marriage is subject to equitable division. A lot of times when I'm consulting with clients about equitable division of property, I hear this, yeah, but I made all the money. And I say, yeah, I understand that you made all the money, but that's not you don't get to keep all the money, okay? You guys were a team, you operated as a team, and now you're gonna have to divide the assets. If Sally decided to stay home so she could focus on raising your special needs child and your other children, she doesn't get penalized for that. You guys joined this as a team. I kind of developed a saying over the years that you have people who come in and say, well, what's mine is mine, what's ours is mine, and what's yours is ours. And that's a lot of the time the way people tend to look at these cases. So when we're dealing with marital property, the court only has the power to divide the stuff that's marital, okay? And that's the things that were generated during the marriage. So any money that John has acquired through his income through the law firm, any money that has been raised on investment accounts, growth in investment accounts that has been, where the basis of which is the marital income, that's all going to be subject to equitable division. The court has the power to divide that, okay? What the court doesn't have the power to equitably divide is our separate property. Okay, separate non-marital property is not subject to equitable division by the court, and it is defined generally as follows. Now, this is my rough definition because we could get into all different kinds of categories, but this is the key stuff. Property owned by a party prior to the marriage and all appreciation thereon that was not caused by the labor and investments of the party during the marriage. So in a situation like this, change the fact pattern a little bit. I didn't put in that John had any premarital property, but let's assume that at the time of the marriage, John had an IRA. And that IRA had $200,000 in it. Okay, I'm just pulling a number out of the air. If John doesn't touch that IRA and just leaves it invested and just forgets about it for the last 30 years, and it has now grown with the market to a fairly high amount of money, John's going to be able to claim that all of that money is my separate property. I have not done anything. I have not gone in and contributed any money that I generated with marital efforts to that IRA. So the money that's in there and the growth on that IRA is all mine. And the court if the court makes a determination that that is his separate property, the court cannot equitably divide that property to give it to Sally, even if the court wanted to. Okay? Now, there is a workaround on that, and I'll get to that in a minute, but that's the general idea. So premarital property is one of the first things that we deal with. Property received by one party during the marriage is a non-spousal gift during the marriage. Another question I get a lot is, well, he gave me the tennis bracelet, or she gave me the Porsche during the marriage, that should be mine. Gifts between spouses do not give rise to separate property claims. But if great Aunt Ida gives somebody a $50,000 watch, that $50,000 watch it belongs to whoever that party is. If the gift is to the marriage, both parties in love and affection, then it's going to be a marital asset. Property that was received by one party as a result of an inheritance or bequest. Go ahead.
Question is, post the $200,000 contributed to a 401k, rolls that into the IRA. If now that it's commingled, does that change the outcome?
It does, and I'm going to get to that right now, actually. Because what you've got is what's called a Thomas analysis. There's a case called Thomas versus Thomas. What happens is, using that example, or the more common example, is someone just keeps the same IRA or 401k and they just keep contributing to it, right? You have to determine, and you hope, after a 30-year marriage, if I'm representing John, that there's some record to say how much money was in that account at the time of the marriage. Because if I can go back and show, okay, well, when they got married 30 years ago, he had $200,000 in that account, and he has subsequently contributed up to, let's say that $3 million account that I talked about in the beginning is now largely with marital contributions, we would conduct what's called a Thomas analysis. And we'd get a financial professional, usually a forensic accountant, who's going to look at that money and determine how much of that money was the initial investment and the growth on that initial, at the time of the marriage investment, and how much of that money is post-marital contributions and growth on that. So you'll have like a breakdown. So it might be that we say, okay, well, after 30 years, 30% of that account, that IRA account, is separate, so we're going to take that off the table and we're going to divide the marital portion, the remaining 70%, and split it up between the two of them.
So if it's not commingled, it stays as is, 30 years later, that's still his?
Not, no, well, if it stays as is, yes. When you said commingled, I thought you were talking about the title.
Sorry,
But
so
if there's no additional contributions, conceptually, yes. Subject to the workaround I'm about to tell you about, yes. From an equitable division standpoint, if the court, let's say that Sally doesn't have an alimony claim, because that's alimony's how we're going to solve that problem. But let's say Sally doesn't have an alimony claim in her case. There's enough assets, she just, for whatever reason, I don't know why she wouldn't do it, just out of an abundance of caution. Say she doesn't assert an alimony claim. Well, in that situation, the court is going to be convinced, if the court is presented with evidence that the money in that account has just been sitting there for 30 years with no contributions of marital assets, then the court is going to lack jurisdiction to come in and say, all right, I'm going to split it up and give it to you and give it to her, because it's just separate property. So that's to answer your question. Yes?
How would they address the fungibility of money? Because the reason money was untouched is because they're making money during the rest of his life, right?
Yeah, I mean, so if he's contributing the money and putting it somewhere else, wherever he's putting it is going to get dealt with as a marital asset. So if he's created a 401k or he's done something else, a lot of times we see it also with pensions. Every once in a while it's always somewhat exciting because you don't see them very much anymore. When you get a real old school pension, like an IBM pension or something along those lines, those pieces of it are generally where you have a lot of, post-marital and premarital contributions. But if you have a situation where you have an account that is not being contributed to, then generally you can assert it as separate property. But that's the, hopefully I've answered everybody's question. We've talked, I think I was talking about property that was inherited. Kind of makes sense. If your grandmother leaves you, a piece of land out in central Georgia, some timberland, and she wants it to stay in the family, it shouldn't necessarily be given to both people in the context of a divorce case. And there are certain trust aspects and certain aspects of personal injury settlements. We're getting kind of down in the weeds on it, but for example, if you have a personal injury settlement, let's say someone's got $2 million because they lost an arm, God forbid, in connection with an accident. The personal injury, the part of that settlement that is related to anything other than lost wages is generally considered separate property. The portion of that settlement that is related to lost wages, which kind of makes sense when you think about it, is going to generally be treated as marital property. A practical tip for financial professionals and divorce lawyers alike. There's a concept out there called lurching, and some of this might depend on how you work with your clients and how much involvement you have in titling of their assets, but there's a concept called lurching. It's under the case of lurch versus lurch. And I think most divorce lawyers will tell you that we've developed this parlance for this case of lurch. Lurch doesn't exactly say what we all think it stands for, but we all kind of just rely on it for that principle, and it's kind of an easy word that we use, and I guess it's kind of fun to say. But lurching property is where you take separate property and through titling it in joint names, you have now made it marital property. So this happens a lot because let's say someone is getting married, they own a premarital home, they own it free and clear, it's a bungalow over in Decatur, they've decided they're going to move into their nice new house over by Emory, and they're getting married, and they say, okay, I'm going to take the money from the sale of my premarital residence, I'm going to put it into my new residence. So you've got separate property in the premarital residence, and then they go to closing, and the wife or the husband, whoever the other party is, says, why am I not on title? And you have this moment that I think most people would experience of, do I care more about preserving my separate property, which I probably don't even know about unless I'm a divorce lawyer, or do I keep my spouse happy? So in that situation, they will generally put both parties' names on the piece of property. And when you do that, if you put it both on an investment account, a brokerage account, bank account, whatever it may be, you've created, I think the rule would just be to say this, you've created a presumption that you have intended to gift your separate property to the marriage. So now that property is subject to equitable division. So if we take, and an IRA doesn't really work because it would only be titled in one party's name, but let's say someone has a premarital brokerage account with $200,000 in it, just like $200,000. And at some point, the wife says, or the husband says, hey, if something happens to you, how am I going to get access to that money? They say, don't worry about it. I'm going to put your name on title to that asset. So if I get hit by a bus, you won't have to go through probate to get that money. Well, what that now does is when the spouse whose name was put on the asset comes to talk to me and says, well, what do we do about this asset? I'm going to say, well, it's marital. I mean, the court has the power to do what it needs to do now that it has been lurched and that's the concept. So therefore, when you are talking with clients about how to title assets, or if you're doing any estate planning or financial planning for clients, and you think, all right, I know I've got this relationship with this person who has a lot of money, they're coming into a marriage, or they're doing whatever they're doing, you just want to watch out for the concept of just kind of saying, oh, why don't you just put it in joint names, or put it in the other spouse's name? Because now you've just created a presumption that that money is now marital money. So that's something to be careful about. How are we going to analyze the assets from Sally's perspective? Okay. Are liquid assets better? Now, part of what we've got in this situation is we have a fair amount of what I would call liquid assets, right? We've got a lot of retirement. It might not be liquid in the traditional sense. It's not just pure cash, but it is, once you hit 59 and a half, generally fairly liquid, subject to being taxed. You've got money in a brokerage account. You've got cash. Then you've got a number of quasi-liquid assets, such as the equity in real estate. And then you've got some assets that are presumably not very liquid, such as the interest in the business or the money that he's got in his capital account with his law firm. Liquid assets may be better. Sally may be a gambler when it comes to her financial future, and she may say, look, I think John's assets in these, or his interest in these businesses have a real potential to get a lot of money. Sometimes they get a really sophisticated spouse who's been watching everything that their spouse is doing about where investments are. And they say, well, he says this thing Google is a really good idea, so I'm going to ride along with him on it. So do we want to stay in those investments, or do we want to kind of cash out? That's another question we're going to be asked. How do we value John's interest in the law firm or the business interests? What experts do we need to hire, and are the assets even worth value? Okay. A lot of times, and I've probably been guilty of this in my earlier career, you want to uncover every rock, every pebble underneath every rock. And if you have a small business interest, do you want to spend $50,000 to value an interest that's worth $10,000? It doesn't generally make a whole lot of sense. So one of the things you want to do is you want to look at issues that, or I want to do, is look at issues about things like personal goodwill. Okay? Personal goodwill and enterprise goodwill, I don't know if that's a concept that is generally addressed in your field. Mike, is that something you guys ever talk about? So basically, let's say you have a business. Coca-Cola has enterprise goodwill, right? If someone wants to go and buy Coca-Cola, everybody knows the name Coca-Cola. You're buying the brand, you're buying the company, you're getting a lot of value. Dr. Smith, the psychiatrist in this old office up by, up in Alpharetta, who just basically incorporated for the sake of liability purposes and tax purposes, that's all personal goodwill. People are only going to Dr. Smith to see Dr. Smith. So if Dr. Smith goes to sell his practice, other than perhaps his office furniture, he's generally not going to have any value in that practice. So we're going to look at what assets are worth value, and if there's any value to Sally in spending the money to go through it. Now, experts that we'll hire, a lot of times we will bring in, either if it's a really big interest, we might bring in private equity people to come in and talk about, how they would value an interest if it's a big enough asset. Sometimes we're bringing in just typical business valuators who do things with regard to M&A transactions. I try personally to not use what I call the usual suspects. There are a number of folks who practice in the area of divorce who generally will value anything, dental practice, yogurt shop, tire store, because that's just what they do, and they value them in divorce cases. But we're gonna look at that. What is Sally's economic risk tolerance? Okay. Does Sally know about the investments or want to ride along? A lot of times people just say, I don't know about what my spouse is up to. They're invested in all kinds of crazy stuff. I just want to figure out how much it's worth and get out. Okay? Some people say, as I said before, I think that my spouse really knows what they're doing and they're invested in something that is very valuable. So I want a piece of that action, and if it's going to go up, I want to ride along with them. So those are some of the questions we're going to be asking. What are Sally's economic needs? I talked earlier about the financial affidavit. I need to know what Sally's burn rate is on her money, because if Sally's burn rate far exceeds the assets she's going to be getting in, at some point she's going to be running out of money. And I told you early on, what I want to do is I want to keep Sally, solvent, for lack of a better term, for the rest of her life if I can. Okay, I want to meet her needs. If I can do it, and if the money's there to do it, and if I can pair her with someone who can help her do it, that's what I'm going to focus on. Can Sally keep the same lifestyle? Again, she may not need to. She may be at a point where she's ready to downsize and maybe get rid of that big house in Atlanta and buy a nice condo in Buckhead. But can she keep that lifestyle? And can we meet her economic needs with reasonable certainty? Okay. When I've talked with folks previously about people who work in investments and financial advisors from various backgrounds, one of the things I talk with them about is, what do you think a conservative or reasonable growth on the money you can get for a client would be? Because I'm generally, if they have enough money, I'm generally dealing with someone who might not have a huge window of time to amass new assets. So I want to know, what's a reasonable growth rate that I can talk to my clients about? Is it 3%? Is it 4%? What do you think it's going to be, so we can try to put this person in a position to live out the rest of their days in comfort? And that goes to the issue of, can the assets be grown by a significant amount such that Sally's not going to run out of money? Okay, because that's, again, my win. Alimony. Everything just changed with regard to alimony. And anyone who might be in this room who's paying alimony or receiving alimony or has paid it in the past, it's different now, okay? There are three types of alimony that we need to be dealing with: periodic alimony, lump sum alimony, and alimony in kind. Periodic is your classic alimony. I'm writing a check for $5,000 a month, every month, for the next 7 years, or until I die, my ex-spouse dies, my ex-spouse remarries, whatever the case may be, the terminating events. Lump sum alimony is non-taxable alimony. I'm marking, note the tape, big asterisk in a second, but lump sum alimony is non-taxable alimony. I'm going to give you $500,000 in lump sum alimony. It's akin to a property settlement. It's one of the ways that we can deal with buying people out of perhaps separate assets that arguably they should have some kind of a claim to. So lump sum alimony is a non-taxable event. Alimony in kind is when you give property. So for example, if someone has a premarital home, they owned it free and clear at the time of the marriage, and then they go and they live in that home for the next 30 years, and at the time of the divorce, they say, this is our home, even though it's been titled in one spouse's name and it was owned as separate property. The court can award a house that's separate property as alimony. So when I said before, in response to the question about separate property and the ability to divide, if Sally has an alimony claim, John won't because of his income, but if Sally has an alimony claim, the way that she could get to the separate property is asking her to be awarded to her as alimony, either as a lump sum or as alimony in kind. So the court might say, look, I can't give her half of that retirement account because it's all separate, but I can give her a cash payment that would kind of even things out if I think it's in her best interest to do so. Alimony, and I use this example a lot, alimony is based on two things: need and ability to pay. Alimony is not payment for services rendered. Okay? Alimony has become this very odd concept in popular culture, and I think because it's a really easy metric for people who are sitting around Hal's or the St. Regis Hotel Bar or the other haunts that I hear a lot about, to compare their divorce settlements. Okay? I'm getting $20,000 in alimony from my ex-husband. How great did I do? Or he's saying, I'm not paying her a dime. I must have done so well. It's an easy metric. It's something that we all kind of compare. It has nothing to do with how well you did in your divorce case, because the guy who's paying nothing may have given 60% of a $20 million estate to his spouse, or the one who took the $20,000 a month may have just been cashed out at effectively 40% of the net value of the estate. You never really know. What is very important about alimony, and specifically periodic alimony, is that prior to December 31st of last year, periodic alimony was tax deductible by the payer and taxable as income to the payee. Okay, so it was a very easy thing for us to say to people, like, this money is not going to cost you 100 cents on the dollar if you're paying it as alimony. As part of the Tax Cuts and Jobs Act of 2017, the big tax law change we had 2 years ago, they got rid of the deduction for alimony, and they did it really fast. And they realized that perhaps we don't want to incite a mass rush of divorces across the United States, so they decided to postpone it for a year, and they pushed it back to 2018. What happened was they were realizing that the spouse who's paying the money is deducting it at a higher tax rate than the spouse who's receiving the money is paying the taxes. So it was not really revenue neutral, so we had a big gap in revenue for the United States government as far as the alimony. When they got rid of that, there was this rush to get everybody divorced before the end of last year. I dealt with it. It was not fun. especially when the judge is not there and has decided to take an early Christmas break and you have no way of getting things signed. There's some workarounds, but we managed to get it done. Why is this important? Because making alimony deductible incentivizes spouses to pay alimony, and by eliminating the deduction, moneyed spouses are far less willing to pay alimony to his or her ex-spouse. I used to say to clients, when we would be going through kind of figuring out what makes sense economically for them, I'd say, look, yeah, you can say you're getting $25,000 a month in alimony, and that sounds great, and it sounds like you did an amazing job. You're going to pay taxes on that at an effective tax rate of 35 or 40%. I'd really much rather get you a bunch of assets that are going to be taxed at a capital gains rate that you don't have to pay ordinary income tax on. You're doing better. It was an argument I could make to a lot of my clients, and after a while, when they got through the haze of the ideas of emotion and rage and what their friends are telling them and all this kind of stuff, generally you could help make that make sense. Can't really do that anymore, okay? Because now what they're going to say is, that's dollar for dollar for me. It's treated the same way now that we treat child support. So if alimony is getting paid now, if he's supposed to pay you $20,000 or you're supposed to pay him $20,000, then they're getting $20,000. It's a dollar for dollar issue. So now assets, for example, that investment account that was going to be taxed at a capital gains rate when they took the money out, that now is less desirable than just getting paid going forward. Now, of course, there are caveats to that. You're relying on someone else to be able to pay you the money. Someone could go bankrupt, they could try to modify it, they could get hit by a bus and then you don't get it, though we typically would secure it by life insurance for that reason. But there's obviously risks to that, but now it's completely changed the calculus of how you try to value a divorce case and how you try to get people out of a divorce case because those tax laws have changed. It did not. And the nice thing is it also does not, I don't believe it applies retroactively to modifications of prior alimony awards. So if you have taxable alimony from a couple years ago and your income has dropped precipitously and you say, I can't afford to pay this alimony anymore, because I believe it goes retroactively to the date of the prior decree, so you're not now having to pay non-taxable alimony. We've talked about this. So the factors that are going to be considered in determining whether how much alimony someone should get are under OCGA 1965. It's statutory. The court doesn't have to consider all of these. These are just the factors that they can consider. Standard of living established during the marriage, the duration of the marriage, age, physical health, emotional condition of both parties, financial resources of each party, where applicable, the time necessary for either party to acquire sufficient education or training to enable him to find an appropriate employment, contribution of each party to the marriage, including but not limited to services rendered in homemaking, childcare, education, and career building of the other party, condition of the parties, including the separate estate, earning capacity, and fixed liabilities of the parties, and such other and relevant factors as the court deems equitable and proper. Of course, number 8 basically gives the court carte blanche to think about anything that they want to think about when deciding what makes sense, including, it's not in here, but you could make the argument that would include conduct. Like someone was a real jerk during their marriage, maybe I want to give them a little more alimony. So what we're looking at here, when we have a person like Sally from our fact pattern, Sally has training, she's a lawyer, right? But she hasn't worked in, I can't remember how many years I said, at least 18 years, right? So, if not more than that. She's probably not an active member of the bar. She's probably not capable of just hopping back into a law practice and making any kind of money that, she probably hasn't kept up with her CLEs, probably isn't still a member of the state bar, et cetera. So, when we look at that, she's going to have a need for alimony in that respect. She's probably not going to have time to get trained because she's approaching retirement age herself. So if she goes back to school, she's going to come out of school in her early 60s. So this is probably a fairly good case for alimony. Again, long-term marriage, age, physical condition, approaching retirement age, and the contributions to each party to the marriage. This is where you get into a lot of arguments with the spouse who's supposed to pay alimony. Because the idea is, I earned it all. And I said, yeah, but she raised your kids. And so she deserves to not be penalized, okay? Condition of the parties, including separate estate. Again, one of the things that happens, and I didn't put it up here, but it is something that to be considered, both with alimony and equitable division of property, is a separate estate of the parties. So if you have a situation where, let's say, hypothetically, someone comes into a marriage with $25 million, and the other spouse comes into the marriage with $100,000. There's $1 million in marital property. is a fair division of that property to say, let's just split it 50-50. So one of us is going to walk with $600,000, the other walks with $25.5 million. No. So the court in that situation can look to the separate estates of each party, their premarital property, and can make a determination as to what needs to happen in terms of the allocation of assets. And they can also do the same thing in connection with separate property. So we've talked a little bit about this. We can assume that under these facts that she's likely to receive no less than half of the assets if we go to court. Most people do not want to go to court. I like going to court. It's kind of why I do what I do. But a lot of people don't want to put their assets in the hands of a judge to decide, who's never met them, or, yes, in Georgia we do have jury trials. People don't realize that. Not on child custody, but on financial matters. They don't want to put their money in the hands of 12 jurors to say, how do you divide our assets, right? So in this fact pattern, John is the bad actor. If I'm going to determine someone has kind of got conduct issues in the divorce, it's John who stepped out of the marriage and caused the separation. So I'm not going to assume that Sally is going to be penalized for that. So she's going to at least get 50% of the assets most of the time, absent some unknown facts. This would mean she'd leave the marriage with assets valued at about $6 million. Whether there is a need for alimony may depend on whether that more than $6 million prudently invested will provide sufficient income to pay Sally's expenses. And it is likely whatever asset division Sally receives will not be $6 million net of taxes. Because if she's getting retirement, it's going to be taxed at ordinary income. If she's getting investment appreciation, might have some capital gains, it's going to cut into that $6 million. There's a lawyer who was actually a former partner of my current partner's, who once, I believe he was trying a case, and he stood up in front of a jury, and it was a very large asset case. And I won't give you the specifics, but he basically said, don't pay her alimony, give her $20 million, make her one of the richest women in the city of Atlanta, and let's just call it a day, right? Because that sounds conceptually attractive to a jury who's never going to see $20 million get thrown in their direction. So we have to decide whether that's $6 million, if she's going to have enough that she actually has a need for alimony. Then how long is John going to have to pay that alimony? If John thinks he's going to be forced out of his high-income job in 5 to 7 years, modern courts, in my experience, there was and I hate to tell war stories, but there was a story that I was told not too long ago before my time about a dentist who was working so hard because he had been ordered to pay lifetime alimony to his spouse that he literally died in the chair at age 88 while still trying to work to pay his alimony. Courts are not generally going to do that anymore. Lifetime alimony can still happen, it does still happen, but it is very rare, okay? It is much less common than it was a long time ago. Courts generally don't believe, in my experience, and this is just a personal observation by me, in indentured servitude. In other words, they say, look, if your plan all along was that he was going to work until he was about 65, 66 years old, I'm not going to now award him so much, I'm not going to award so much alimony that you have to now work until you're in your 70s, right? I mean, that's just generally not the concept. So that's going to be an issue. Can John afford to pay a big alimony payment now that he can't deduct his alimony? This is something we're all now kind of figuring out, right? Because child support under Georgia law, which I'm not really talking about, but is generally based upon a table. Alimony, there is no table. Alimony is based on what you need and what you have the ability to pay. So now the issue is going to be much more, he can't deduct it, how's he going to pay? John's going to have at least 5 more years to earn. Sally's not. For Sally, this is probably the chance that she's going to have to get whatever asset she's going to walk away with for the rest of her life. John, he might have another 5 years to earn, I think I said $800,000 a year. So he's going to have some time to rebuild his estate. So those are the types of things that we're going to have to look at to determine whether or not Sally really needs some alimony or John's going to have to pay it. So before I move off, does anyone have any questions about alimony, equitable division? Yes?
Yeah. For the non-working spouse, is there any theory in the courts or that lawyers attempt to push onto the parties that you're young enough, you can be retrained, there should be money to retrain you, and then you should be able to support yourself?
Yes.
Is that part of
Oh, absolutely. I mean, what we call that is rehabilitative alimony, and a lot of time that's what alimony is intended to do. Now, in this example, I put Sally at an age that's so close to retirement age that the time to get retraining is going to put her pretty close to retirement age anyway, but it is not at all uncommon that I'll have clients who are in their late 30s, early 40s, who can go back to school, and we will say to these people, you're going to need to go get a job because the court is not going to take care of you for the rest of your life. You can't expect that to be the case. A case like the one I've described in the fact pattern is kind of I don't want to say it's an easier case for a divorce lawyer to deal with because it's not, but it at least provides a lot of assets, which gives us a lot of flexibility. If you have someone who doesn't maybe have a 30-year life expectancy, but instead has a 50-year life expectancy, or the assets aren't quite as big, you're looking at a different ballgame. And I have had many conversations with many clients to say, you know, you're going to need to find work. Either you're going to have to go back to school, or a lot of times, you know, find a job in the family business or whatever the case may be, because you're not going to necessarily be taken care of for the rest of your days. So that does it. Not really. I mean, my experience is primarily when you start getting into the retirement age area is when the court's generally not going to necessarily award much alimony, nor is the court going to say that someone has to go back and get retrained. I mean, we don't need, you know, the 88, as I said, like the 88-year-old dentist example. They're not just going to force people to work until they can't anymore. So. In the back?
Going back when you're looking at assets that need to be valued, what are the, obviously all valuations are opinions and so forth, so what are the biggest issues you run into just getting both sides to agree on what something's worth?
Discounts. Big into discounts. What kind of a discount do we put for lack of marketability? What do we put for lack of control? I mean, yes, you've got the initial amount, right? But we can look at the financial statements and try to generally get in some kind of a similar ballpark a lot of the time. Then the problem is, okay, someone has a 10% interest in the family business. There's all kinds of shareholder agreements that are going to keep this, that are intended to keep this business in the family. There is no way that that person can sell that interest outside the family without 6 rights of first refusal from every other family member and anything along those lines. So is it effectively book value? Is it valueless? How do we look and discount that property? And so if you change this example from a law firm interest, say it's a manufacturing company, and the manufacturing company owns a privately owned manufacturing company, and John owns a 10% interest, okay? He's going to say, I can't get rid of this for book value. If I went out into the market and I tried to sell this for anything higher than book value, wouldn't happen, because Uncle John would come back, Ted would come back, Aunt Sally, I'm using John and Sally a lot, but Aunt Susie would come back, and they'd all have a right to buy me out, okay? On the other side, they're going to say, yeah, it's worth what it's worth. And yeah, your buy-sell agreements and all that, we can factor it in. Those are a lot of the disputes that we have. And in October, I had a 2-week trial basically tied to that exact same issue. Okay, that's primarily it. Yes?
Alex, in your experience, what is the equitable split work out for you? Is it always 50-50? Is it somewhere between 40 and 60? Just
Generally, what most judges when I'm in your position, and because I was talking to hearing judges talk on these panels and these things, most judges seem to say we walk into it with this concept of 50-50, and then we'll let the facts dictate to us whether we want to start sliding that closer to 45-55 or 40-60 or whatever the case may be. I once had a judge who has since retired during one of these talks. Someone asked her that exact question. He said, Judge, what does it take for you to move the needle? You know, is conduct, for example. What conduct really forces you to move the needle? And the judge said something like, it was great, she said something, in-your-face adultery. And she used the example of the guy who flew his family down to Florida because they were going on this wonderful Disney vacation, and he decided that his secretary was also going to come down to assist him while they were on vacation, and he took his family to pick up his secretary at the airport and really just threw everything in their face. And the judge said, in that situation, that was just abhorrent behavior, so I'm going to start moving that needle. Then you've got a situation, if you have big separate property claims, that's not a conduct issue, that's just in a separate estate of each party. So I think if you come to the judge and say, Judge, all right, we got $1 million, but he's got 50 in the bank and she's got 100, then I think the judge is going to be looking at, we would say this is not a 50-50 type case. So, any other questions on alimony, equitable division, anything like that? Yes?
This is going to depend for your you always said that you came to divorce before you came ready.
Mm-hmm.
And I actually had a client who was a CFO of a major hospital, and she was widowed, and she got remarried. She did everything from stocking her 401k and setting up a brand new 401k with the same employer, so that there wouldn't be any commingling of assets aren't on the marital stuff. And then I think, why instead of adding someone's name to the account, I guess I'm asking this, they're not the list of bullet points, like you can, instead of having joint accounts, you have payable on death, or you have beneficiaries. Is there like some cheat sheet that tells people to do this?
Well, not one that's unless you're a divorce lawyer, not really. I mean, because there are things, before I started doing divorce law, I realized like everything, I love my wife dearly. I'm gonna start with that. I love my wife dearly. But I did everything that you probably shouldn't do when we were getting, put everybody's name on everything, put everything in joint names. Like, I want to, I love my wife, I want to be happy. And that's what people do. So when you have someone like in your client's situation who maybe knows, look, I have some stuff I want to protect, I wish there was a bullet point, but there isn't. I mean, bankers don't come out and say, don't put your spouse's name on the account because then you're going to have a divorce problem, because they just don't know. I mean, they just don't know. A lot of times the way that gets dealt with is they say, go get a prenup. And that's typically what we see. Prenups are generally now acceptable in Georgia. It wasn't before 1982 when the Scherer versus Scherer case was decided. Under Scherer, that's, for us in my profession, that's the base font from which everything has flowed on the language of prenuptial agreements. Under Scherer, to have a valid prenuptial agreement in Georgia, you have to meet a three-pronged test. Was the agreement obtained through fraud, duress, or mistake, or through misrepresentation or non-disclosure of material fact? The answer to that has to be no, it was not. Is the agreement unconscionable, and have the facts and circumstances changed so as to make enforcement of the prenuptial agreement unfair or unreasonable? Prenuptial agreements in Georgia. I don't know that I've ever actually seen a prenuptial agreement get set aside or not enforced because of 2 or 3. Okay. Unconscionability and have the facts and circumstances changed so much. We don't have a tremendous amount of case law in Georgia, and just so y'all understand this, there was so little law in the area of family law and divorce in the state of Georgia that the Georgia Supreme Court basically said, okay, we're just going to start taking all the family law cases because we need to create law because we don't have enough to dictate what's going to happen. Now, they've since kicked it back down to the Court of Appeals, but there's not a huge amount of cases on prenuptial agreements. There's a good number, but not a huge amount. Unconscionability, good luck. I mean, if you can find the case, and I know none of you are divorce lawyers, but if your friend who's a divorce lawyer can find the case that kicks out a prenuptial agreement on the grounds of unconscionability, I would love to read that case. Unless someone is effectively holding a gun to your head, and I'm not using that like figuratively, unless someone is literally holding a gun to your head as saying, sign this agreement, Georgia courts are very keen toward enforcing those agreements on the grounds of unconscionability. One of the cases we have, and I was actually looking at it outside as I was getting ready to come in here, because I remember it is this case called Mallon versus Mallon. And in the Mallon case, you had a situation where a woman had been dating a gentleman. She had become pregnant. She had gone to a clinic to terminate the pregnancy. He calls her and says, don't do it, marry me, I'll take care of you. And he basically, a couple days later, says, now just sign this prenuptial agreement, okay? The court said, that's okay, because she said, I was going to terminate my pregnancy, now I was going to be single and pregnant, and I didn't feel I could do that anymore, and the court said, sorry, that's not unconscionable. That's not, the fact that he did it, not a problem. Have the facts and circumstances changed so as to make enforcement of the prenuptial agreement unfair or unreasonable? The only thing I could really see ever happening here, and I'm not aware of the case that would actually say this, is hypothetically, let's say someone had cancer or something along those lines, that at the time of the divorce they were just in a horrible position. Maybe then the court might look to do something about that. But really, and I hear them clapping, do we know how much time I have? All right, I'll try to wrap it up. Big thing here is duty to disclose. If you want to have an enforceable prenup, make sure you're disclosing your assets and fully disclosing, not just what they are, but how much they're worth. Okay, don't just list business interest in gas station. You have to say, I think it's worth this amount of money. Okay, the cases where you do see things set aside are generally in failure to disclose cases. And the party, in the Kwan versus Kwan case, the party has no duty to investigate the other party's assets before signing the anti-nuptial agreement. I've had fights with my partners as to whether there's a duty to disclose or a duty to investigate. My position is there is a duty to disclose. So if you want to make sure you have an agreement, make sure you disclose everything. Listing assets but not values is not good enough. And this is just some of the reasons we have prenuptial agreements. One thing I will say is, before I wrap up, prenuptial agreements allow you to protect separate property much, much better than you would under a normal equitable division framework. So you could even say, hypothetically, I have a separate interest in this oncology practice. I'm an oncologist. I have a separate interest in oncology practice, and I have decided that not only will my oncology practice be deemed my separate property if we get a divorce, all the money that I earned during our 20-year marriage, which would otherwise be marital income, that is generated from that separate oncology practice would also be my separate property. So it is a much more effective mechanism to protect separate property. And you can do other stuff, choice of law provisions, et cetera. So I think that's it. Thank you very much, everybody.